focus on Chapter 11. And as a reminder, and I will also state that you have the ability to submit questions as we go along. And since Chapter 11 is so complex, please feel free to submit those questions at any time as we go throughout. As a reminder, bankruptcy is a federal statute and applies in all states. Today we're going to focus on Chapter 11. Chapter 11 is known as a business or a corporate reorganization, although individuals can be eligible to file under Chapter 11. Chapter 11 almost always involves a reorganization plan, but the plan sometimes is just to liquidate the entity.
Let's just, let me chime in there and say that Chapter 11 is a business reorganization, so it as Trish pointed out, it can apply to individuals, but a business can qualify as a corporation, a limited liability company, a partnership, any one of those types of entities.
Okay. For an individual to qualify, their debt would have to be very extensive. Basically, they would have to exceed the Chapter 13 debt limits, which would be, for an unsecured debt, it would have to be more than $383,000 and just over $1.1 million in secured debt. And then if that happens, then the individual would no longer qualify for a Chapter 13 and would have to file a Chapter 11. Most individuals would prefer not to have this happen because Chapter 11s are very complex and they're also more expensive to file with the costs and fees. The idea of a Chapter 11, and Scott can probably talk more to this, is the idea for a business to continue to operate and reorganize rather than have an independent stranger, which would be, for instance, like in a Chapter 7 or a 13, you have a trustee appointed to run the business and liquidate it. Instead, in a Chapter 11, we have what's called a debtor in possession that continues to operate the business, which is somewhat ironic sometimes because that's the same entity that put it into the bankruptcy, but it's also the one that's going to continue to operate it and hopefully bring it out on the other side.
Yeah, weird, isn't it, that the people that, for lack of a better term, ran it into a bankruptcy or into the ground are now responsible for getting it out. Typically this happens with the assistance of professionals, lawyers, accountants, and consultants. Depending on the size of the case, the consultants and accounting fees and attorney fees can run into millions of dollars. And so ironically, the people that operated the business before are now responsible for operating as what's called a debtor in possession. The history behind this is kind of interesting because it used to be that the bankruptcy court, through the Department of Justice, would appoint trustees to reorganize Chapter 11 debtors. And so they would choose from the standing Chapter 7 list, meaning people like me, because I'm a Chapter 7 trustee. And they would pick those folks and ask them to do that job, which is to shepherd the case in a Chapter 11. Well, as you can imagine, if, say, Boeing went into a Chapter 11 case and they asked me, because it was domiciled here, to be the trustee in Boeing's Chapter 11 case, I don't think I would, although I'd like to think I would be, I don't think I'd be very successful in reorganizing such a big company. So the way it fell out is that the bankruptcy court and the Department of Justice would appoint standing trustees, and they wouldn't do a very good job. And then because they wouldn't do a very good job, what do you think the creditors of that company would think? They wouldn't be very happy. So what would they do? They'd then sue the trustee for failure to do his job or his or her job correctly. Interestingly enough, then, after that started happening, the U.S. Trustee's Office and the bankruptcy court would ask trustees to serve as Chapter 11 trustees, and they would decline. So the bankruptcy code came up with this idea of appointing the debtors in possession to run the business while it's in a Chapter 11 case. There.
Yeah, and do you want to talk a little bit about the idea that a debtor in possession should not be operating at a loss?
Sure, it's called administrative insolvency. In other words, while you're in a Chapter 11 case, creditors can't take certain actions against the debtor, meaning you can't collect money, you can't sue them, you can't do a lot of things. So giving the debtor some breathing space, meaning it doesn't have to service all of its debt immediately until it files a plan. What you can't do is have the debtor go further in debt. In other words, they can't be administratively insolvent. In other words, if you can't run your business and be at least break even while you're in a Chapter 11 case, then the court and the creditors can dismiss the case. Typically, the Chapter 11 debtors get in trouble with taxing authorities, and especially if the debtor is operating and not paying its taxes, then the bankruptcy court and the bankruptcy police, the U.S. Trustee's office will try and get the case dismissed, because essentially the state of Michigan and its employees are then financing the bankruptcy case, and that's not a good thing.
As Scott mentioned, with the changes, the debtor in possession now in essence assumes the powers of a trustee under the bankruptcy code and exercises the same rights the trustee would have and the same rights and duties of operation, other than the duty to investigate, which is something that is typically done by the U.S. Trustee's office and through what's called the Committee of Unsecured Creditors. If there isn't a committee, then individual creditors have the right to bring issues to the court's attention. It's kind of a checks and balances. When there is a trustee in a Chapter 11, which is not unheard of, sometimes that happens, especially when there's a lot of conflict or question on operations and what's been taking place, then the Office of the United States Trustee will choose from the panel, as Scott mentioned, of the private trustees. And sometimes they have to keep going down the list because the private panel trustees will reject it and to a certain extent don't want any part of it.
I've been a Chapter 11 trustee. The U.S. Trustee's office appointed me to run a number of different businesses, and it's very interesting.
But as noted, it's not automatic that there's a trustee in a Chapter 11 case, unlike in a Chapter 13 and a Chapter 7 case. The Creditors Committee does act just as it shows on your screen there as a watchdog. They can force the debtor to take certain actions, like file avoidance actions and preference and fraudulent conveyance actions that we'll talk about in just a minute. Or the Creditors Committee can take that action itself. The committee can also object to the plan that's filed in the case or can submit their own plan. The committee is relied upon by the court for advice as to how the unsecured creditors are being treated in regard to issues that affect unsecured creditors. Hopefully, in a Chapter 11, what would occur is negotiation between the Unsecured Creditors Committee and the debtor, and probably the top largest creditors of the debtor would also be in part in negotiating the plan that would ultimately be confirmed. The less contention, the better for everybody, but sometimes that doesn't happen. The U.S. Department of Trustee, which is, as we've talked about in the past, different than the private panel trustees, will oversee all Chapter 11s. And the U.S. Office of U.S. Trustee is the one that selects a Chapter 11 trustee if it's needed. The U.S. Trustee's office is also the one that appoints the Creditors Committee to watch over the Chapter 11 case. There's sometimes when an involuntary bankruptcy can be filed, and this can happen in any chapter, but it's probably most frequent in a Chapter 11. And Scott can probably talk about it. It's not most frequent? He's shaking his head at me.
You can have an involuntary bankruptcy petition, and as this slide indicates, you have to have certain requirements. You can have 3 creditors or 12, depending on how much the debt is involved in the case, but you can only file an involuntary Chapter 7 case against an individual corporation. The reason is this: if you're in a Chapter 11 or Chapter 13 case, it's a voluntary repayment, right? So it's voluntary. That's a key word, because you can't force somebody to repay creditors. It would be what used to be called indentured servitude or slavery. You can't make people do that. So they can elect to. You can file an involuntary bankruptcy petition, and essentially what that says is this person's insolvent, and we need a case filed against them, this person or entity. Then that person or entity could say, okay, you're right, I'm insolvent, but I want to pay people back. So this is my plan to do that.
And the reason that somebody would file an involuntary petition against an entity or person is because it has done something to prejudice that creditor, and they want to set the date for that petition because the date of filing is the date that all deadlines and future dates will run. And just a reminder, we've talked about this in previous sessions if you've been with us through all of these. Secured creditors, obviously each type of creditor is treated differently in a Chapter 11, just like in any other bankruptcy case. The secured creditor is the one who holds a claim that has lien on property, at least to some extent, to cover the debt. And an unsecured creditor is one that has no lien and has no collateral to support the debt that it is owed, and generally unsecured creditors have the lowest priority. Avoidance actions take place in a Chapter 11, and that's a way for creditors to get paid, especially unsecured creditors. The Bankruptcy Code permits certain things to be avoided or undone once a bankruptcy case is filed.
So to most creditors, and for the folks that are on this call, this is a pretty weird thing. In other words, we're going to take money back from creditors and pay it out. It's almost like Robin Hood kind of idea. In other words, all of the debtors' financial life prior to the bankruptcy filing for 2 years is subject to scrutiny. In other words, we go back and look at what they did. With respect to preferences, it's the 90 days before they filed. So if while they're sliding into bankruptcy, they're trying to pay favorite creditors or pay friends, pay family, pay other people, debts that they owe, those are called preferences because those creditors were preferred over others. So what we want to be able to do, the idea is to set everything back to even, is we look at the 90 days before they file and we say, you preferred these folks. Those folks have to give the money back, and then we put it in the bankruptcy case, and then we divide it up pro rata amongst everybody else. See the Robin Hood idea? So it sounds weird, but it's supposed to set things right. And the folks on this call may be most subject to getting a letter from a trustee or a debtor in possession saying, you got a preference and you got to fork it over. You got to pay it back. And so if that's the case, then of course you'd call your best bankruptcy lawyers and you'd have a defense to it likely.
Exactly. There are a lot of defenses, so it's not something you should immediately cave into. Even though the language in the letter likely will be very convincing, you should immediately contact your bankruptcy attorney. Just one additional note here. Scott covered everything in the slides as we were going through, but when we talk about that 90-day period prior to the debtor filing for bankruptcy relief, the Bankruptcy Code creates a rebuttable presumption that the debtor was insolvent during that 90 days. And that's important because for a preferential transfer to be enforceable, the debtor had to have been insolvent when it occurred. So that too can be one of the defenses because it is rebuttable. Another type of transfer is a fraudulent transfer under the Bankruptcy Code. It allows a trustee or the debtor in possession to go back 2 years to look at the types of transfers to see if there were things that were shifted around for little or no consideration is one of the things that are looked at. It's also whether or not the debtor had the actual intent to hinder, delay, or defraud creditors. And as we've discussed, the Bankruptcy Code is a federal statute. However, state law is relied upon for liens and mortgage rights and anything that's in regard to the Uniform Commercial Code, which has been adopted in all 50 states. Article 9 covers the creation of security interests on personal property and allows liens that have been created and they will continue through a bankruptcy case and they will not be lost.
So let's just back up one slide or two and go back to the fraudulent conveyances. This is much like the preferences we just talked about, except it goes back 2 years. So we're going to go look to see what the debtor might have transferred to people for no money, right? So they might be transferring property to their parents, their children, or something like that. So we can get that property back. The standard is whether or not they've got reasonably equivalent value, whatever that may be, or they did it with the intent to hinder, delay, or defraud creditors. So once again, we're going and looking at the financial history of the entity that filed its bankruptcy petition to see whether what they did before they filed was offensive of this code, meaning they were transferring assets without getting money in return. Same thing with the preferences. So it all happens 2 years, depending on the statute you're looking at, 2 years or 6 years before they filed. If we slide forward, then I think the next slides concern the creation of liens and security interests. And so the idea here is there's a number of Supreme Court cases that stand for the proposition that if you have an enforceable lien before the bankruptcy is filed, that lien follows through the bankruptcy case despite the fact that they filed. This only makes sense because if that didn't happen, then it would set the entire mortgage industry on its head, and liens in cars, and it would discourage creditors from lending money because they don't have a lien any longer. Ironically, this is a kind of an odd concept, but the debt associated with the mortgage or the vehicle, if the debtor receives a discharge, is discharged and gone, but the mortgage is still enforceable, or the chattel mortgage in a car.
As a lien holder in a Chapter 11, you're required to get notice of anything that would affect your lien. So if the debtor in possession or a trustee, if there is one, is attempting to sell the property, you should receive notice of that as a lien holder if you have a lien in that particular property. And if you fail to act or respond, then your lien may either be diminished or completely lost. So it's important to pay attention to any notices that you get in that regard and to contact your bankruptcy lawyer. The same rule is going to apply, the same concepts for judgments as well. Since state law governs the creation of liens, it's also going to follow the law of judgments and follow through in a bankruptcy case the same laws that would apply in state court. Excuse me. In bankruptcy, much like in Chapter 7s and in 13s, an automatic stay is also in place in a Chapter 11, even though it's a business. The same concept applies that all creditors must stop collecting or trying to enforce a debt as to the entity that's in Chapter 11. The automatic stay, in essence, is an injunction that prevents creditors from collecting. And the idea is what Scott mentioned earlier, and that's to put all creditors on the same playing field, same plane, so that all of them are treated the same way. So if you're in the secured class, all secured creditors are treated the same. If you're in the unsecured class, then all unsecured creditors are going to be treated the same. There are instances when you can file what's called a motion for relief from stay to modify or lift the automatic stay. If you're a lien holder, that may be something that you're interested in doing. It generally occurs when the interests of the lien are being diminished or harmed. So if the Chapter 11 plan doesn't provide for your property correctly or your claim in relation to the property, then you can seek a motion for relief from stay.
So what is it? So what does this all mean? There's a lot of terminology that goes on in a bankruptcy case. Relief from the automatic stay. The automatic stay. Here's the issue: if a creditor has an interest in some property, either real property, a building, house, whatever it is, or a vehicle or inventory, you still want to get paid. It doesn't, the fact that the money's owed just doesn't go away. And so the creditor wants to get paid. To do that, the creditor needs to demonstrate, at least in a Chapter 11 case, that in some form or fashion that collateral is devaluing. You can prove that by a number of different things, but one of the easiest examples is a vehicle. The moment you buy a car, it starts to devalue. You drive it off the parking lot, it's worth 15 to 20% less than what you bought it for. So in those circumstances, if the creditor wants to get paid, you bring a motion for relief from stay, and or you ask the court for what's called adequate protection payments. In other words, and that means exactly what it says, adequate, meaning enough money to protect the devaluation of whatever we're talking about. So in a vehicle situation, you're going to have to pay some money per month to make sure that we're not changing everybody's position, that we remain in the same spot we were when the case was filed.
And once relief from stay is obtained, the only thing you can pursue would be the asset or the property itself. You're never going to get relief from stay from the court to allow you to pursue the debt that you're owed. And it's important to make sure you obtain relief from stay before you attempt to collect a debt or enforce a lien, because violation of that automatic injunction includes penalties such as attorney's fees and punitive damages for contempt of court.
Yeah, so if you're a creditor and you have a debt owed and you have collateral and it's in a Chapter 11 case, for lack of a better term, don't frog around with it. Call your lawyer. You can get in trouble pretty fast.
Yeah, I think some people have the misconception because it's a business and it's not an individual person that, the rules don't apply, or, the courts aren't as harsh, and that's not the case.
Yeah.
Rules apply equally.
So now we've moved on to first day orders and some other things that occur in Chapter 11 cases. So once the case is filed, then a whole bunch of stuff happens. Most of this you'll never be involved in or see, but what happens is there's a bunch of first day orders, meaning to get the case up and running, the debtor has to bring a whole lot of motions in front of the bankruptcy court to get use of cash collateral, all kinds of other what I would consider to be administrative details. And so a lot of orders will come out of that first day meeting or motion day. With respect to cash collateral and DIP financing, cash collateral is nothing more than a creditor having an interest in the debtor's cash. In certain circumstances, lenders will lend money, and when they do that, they will take a security interest in everything the debtor has. That means inventory, right? So when you sell inventory, it turns into what? Cash, right? Once it's cash, then it becomes cash collateral because it's collateral for your loan. So when a debtor files a Chapter 11 case, it can't use cash collateral unless it gets permission from the creditor, right? You go to the bank and say, can I use the cash that's being generated by the inventory? And if you know they're in a Chapter 11, you say no, thank you very much. Or it has to go to the court and it has to get permission. And typically, if it wants to get permission, then it has to make, remember what we talked about before, adequate protection payments, right? So if you're going to use the cash and run your business for whatever business it is, then you have to pay money to the creditor to keep them in the same spot they were. Also, when a debtor files a bankruptcy petition, obviously they don't usually have a lot of money. So they will go out into the marketplace and borrow more money while they're in a Chapter 11 case. That's called DIP financing, debtor in possession financing. You'll see this happen quite a bit. And usually the DIP financing is offered by or made by existing creditors, right? In other words, not too many people are going to loan into a situation where the debtor is insolvent, right? Because they already demonstrated they can't pay. So usually the people that will step up and lend more money to this debtor are the people that are owed a substantial amount of money already. Why? Because in their business judgment, it may be the only way to get paid, right? If somebody owes you 10 million bucks and they need another million, and the financial projections say it looks like it will be able to pay you over 3 years, it might be a good idea. And interestingly enough, once they file and you loan them that new $1 million, you can charge them a lot more interest, and your claim for that $1 million goes ahead of everybody else. Everybody else. All secured creditors, unsecured creditors, everybody. So there is some protection in the idea that you could lend into a bankruptcy case. There are also professional lenders that lend into bankruptcy cases all the time. Usually what they do is charge a lot of money, one, and then two, the trade-off is they're going to take a piece of the action on the back end. In other words, for investing in that business, they're going to get a percentage of the business when it comes out of Chapter 11.
Along those same kind of lines, at the very beginning of a case, certain players, if you will want to take an active role in a Chapter 11, correct?
Sure, mostly the people that are owed the most money, they're going to take an active role. And the ones that are owed the most money and the ones that have the most collateral, they're the ones that are going to be driving the case.
And there are instances when a debtor can borrow for unsecured credit, such as to obtain inventory or goods or materials.
Sure, if you think about a Chapter 11 case, they're operating the same business they were before, right? So once they are in a Chapter 11 case, then they have the ability and authority to enter into contracts and do the things that they were doing beforehand, right? Ordering inventory, ordering whatever it is that they need, services, goods. And so there is a certain amount of credit being extended post-petition, right? Because if I send you inventory, you're not going to pay for it immediately. So there's a credit relationship there. And so the debtor can do that within certain constraints and get creditors to extend short-term credit. Interestingly, if you do that, meaning if you're a creditor, excuse me, and if you're a creditor and you're going to lend post-petition or you're going to extend inventory financing, you are then termed to have a administrative claim, and that administrative claim takes priority over everybody. So if you're the person willing to lend into a Chapter 11 case, your priority in the system goes up. Only makes sense because we want to encourage people to do that. Some of the players on, so we're talking about early positioning, some of the players may want to get involved in the creditors committee and some may not. It really depends on the people and their position. It doesn't take a whole lot to be on the creditors committee. You meet every once in a while. Ironically, why Chapter 11s are so expensive is that a Chapter 11 debtor, where there's a creditors committee, has to pay the expenses of the creditors committee. So if you fly to New York for a meeting or you have to do something like that, the debtor has to pay for that. One of the other expenses of the creditors committee is to hire counsel. So the debtor, when they file their bankruptcy petition, has to pay for the creditors committee expenses, which includes the lawyer that's going to advise the creditors committee about bad stuff they want to do to the debtor. So you actually have to pay the opposing party's lawyer. That's an insult to injury, isn't it? That's the best work in the history of the planet, to be the creditors committee lawyer, because your boss is not paying your bill. You can do whatever you want, and they have to pay you.
Yeah, and sometimes they're at odds with one another.
Yeah, absolutely. Yeah, we can slide on from there.
I just want to note, when you are on the Unsecured Creditors Committee, the committee as a whole is looking to better the position of all unsecured creditors. So even if you're on the committee, you're not there, obviously you're there for your own interests and your own debt that's due you, but it's going to be the entire committee and the entire pool of unsecured creditors that benefits from the actions of the committee.
Yeah.
I'm going to talk about the Chapter 11 plan a little bit and when that gets filed and the negotiation that takes place.
Well, it can get filed anytime. The best case is a prepackaged plan. In other words, before you file your bankruptcy case, the best thing to do is go talk to your creditors and work out a deal in advance. You'll see that in the press. It'll say they filed a prepackaged plan. What that means is that they've already talked to everybody and they got it pretty much worked out. If not, it gets a little sticky, because then once the plan's been filed or the case has been filed, you have to go back to your creditors and now work out a deal. That can happen anytime during the case, after the case is filed. The earlier the better, and during the first 180 days, the only person or entity that can file a plan of reorganization saying how we're going to do this and pay it back is the debtor. After 180 days, anybody can. a creditor can, or opposing people can do that. I haven't seen it very often, but it can happen. And then the plan will essentially lay out who's owed what, who has security interests in what we anticipate we're going to be making in terms of revenues, and how we're going to divide those revenues up and pay them out to everybody. That's essentially what it is. It's just a plan to pay everybody back. Once the plan's confirmed, then that whole plan becomes essentially, under bankruptcy law and state law, a new contract with the creditors. So everything that happened pre-petition, right, is gone, and now that plan is what governs what our relationship is. So if you were owed monies pre-petition and they were supposed to pay you back in a certain way, if the plan changes that, now they pay you back according to the plan.
And that's somewhat significant too, because you may have heard people say that corporations and limited liability companies don't receive a discharge of debt. So the idea is, well, then why do they file bankruptcy? Well, a Chapter 11 plan modifies how they pay back that debt. And so if the plan modifies your claim down or crams it down, then the part that is in essence extinguished isn't per se discharged, but it's gone, because that plan is now the new contract between you. And that also includes unsecured debt. So that's the form and way that the debt is extinguished by that corporation or entity. So that's why it's important to pay attention to the plan.
The next slide, we're talking about more bankruptcy lingo. This is the disclosure statement. That's nothing more than a piece of paper that says, this is our business, this is how we used to run it, these are our customers, this is what we believe is going to be our business in the future, and this is what we're going to make. It's a disclosure statement. We're disclosing to you what it is that we think happened in the past and what we're going to do in the future. There's certain limitations on when people can solicit disclosure statements. This is almost ancient kind of bankruptcy law that nobody worries about anymore, because the disclosure statements and the plans of reorganization have been combined by most courts to make the whole thing a lot smoother. It used to be it had to take a disclosure statement and you had to wait a certain period of time, have a hearing on that, and it just got cumbersome and long, and so now everybody's combined the two. Okay, so we do have a question that came in. The question is, can a creditor at any point during a Chapter 11 file a claim if the loan is partially or fully backed by the SBA? One, I think creditors should always file claims as early as possible, especially in a Chapter 11 case. Now, it works out that if you don't file a claim, but your claim is treated in the plan, that there's no harm, no foul, you're going to get paid. But it's always better to be waving a flag over in the corner saying, hey, I'm owed money. So one, file a claim as early as possible. And two, the question about the SBA, which is the Small Business Administration, is a little more complicated, and it depends on the circumstance of the SBA guarantee. In most cases, and when the case gets to a Chapter 11 case, the debtor's going to be in default, and once they're in default, that SBA guarantee kicks in. Excuse me. So, my experience with the SBA over 20 years is that they have plans that have to be approved by the SBA for your liquidation of the debt. And so part of the liquidation of the debt would be this Chapter 11 case. You have to go back to the SBA, tell them that the debtor filed, get a plan together about how you're going to treat the debt, and then at some point in time get them to acknowledge that you, the creditor, the bank, the lender, is authorized to file a claim on behalf of the SBA. But typically the SBA is a guarantee, and until they pay, they don't have a claim. And typically that claim is then, in one form or another, transferred to the borrowing entity or the lending entity, because the SBA doesn't want to be involved in all of that. So I hope that answers the question. All right, so once the plan's filed, everybody gets to vote on it. The only people that get to vote are the ones that have their claim impaired, meaning that they've lost some right. It's either length of time they're getting paid, interest rate, something, anything that would change what happened to the relationship before the bankruptcy was filed. That's called an impaired class, and they have to vote in favor.
And upon confirmation, the court issues an order confirming the plan, and once that's entered, as stated, that's the new contract between all the creditors and that entity in bankruptcy. And if it's not appealed, then the plan goes into effect. Have you ever seen an appeal of a Chapter 11 confirmation?
I've seen creditors bring motions to have the confirmation order in some form or fashion modified or rescinded, meaning they went back to the court and said, you shouldn't have done that for one reason or another. Mostly what that relates to is what's called substantial consummation, is another bankruptcy term, right? Substantial means pretty good, a good amount, and consummation means that we've actually done something to implement the plan. So substantial consummation means, okay, now they've taken the steps that they said they were going to take in the plan to start reorganizing and paying everybody back. And so in some certain circumstances, they'll file a plan and get it approved, and then whatever the financing was or their plan to begin repaying people didn't come through. And now all the creditors are standing there going, what's going on here? And so if you don't start, if there's no substantial consummation after the plan's filed, you can ask the court to rescind the confirmation order. So these are just the steps of what you should do in a Chapter 11 if you get notice, which is obviously stop collecting, monitor the case as much as possible. If you're a secured creditor, in the Chapter 11 case, there's no co-debtor stay, meaning the people that guaranteed the debt are not protected. So even though the debtor filed a bankruptcy petition, you can go after the principals, right? You can sue them on their guarantees.
But if you want to go after the collateral, then you're going to have to seek relief from stay because that collateral is part of the bankruptcy case.
Correct.
If you're a secured creditor in Chapter 11 and you have security interest in assets, and especially if you have a security interest in the cash collateral that we already talked about, you really have to contact counsel. Unless we have any more questions, I think that wraps us up. Well, we talked about filing a proof of claim. You want to do so within 90 days. As Scott mentioned, if you're provided for in the plan and the only chapter in a bankruptcy is Chapter 11, you technically don't have to file a proof of claim. That's not true in Chapter 13s, Chapter 12s, or Chapter 7s. But you're always better safe than sorry, as they say, to file your claim. So number one, it's clear to everybody how much you're owed. It shows us you're going to file documents along with it, or your counsel is, that shows why you're owed that money and how your interest is perfected if you have liens. And so it also informs everybody else that thinks that they may have a right to that collateral or property. You've now put everybody on notice by filing that claim. You should do so sooner rather than later, but no event later than 90 days after the bankruptcy case is filed. And you want to make sure you review the disclosure statement in the proposed plan for your creditors, your rights, and how they're treated. If you're an unsecured creditor, then you're going to go to the unsecured portion of the plan and look to that. And you should discuss with counsel whether or not you think relief from stay may be appropriate.
Yeah.
Yeah. And always remember, we can't stress enough, violations of the automatic stay or a post-discharge injunction are sanctionable. And unfortunately, there are attorneys out there that is how they make a living, by finding these violations and then representing the entity, the debtor, because attorney's fees are recoverable. So you want to make sure that you don't get caught in that sling, so to speak.
That's it. Thank you
We're
very
all
much.
set. Thank you.